Good morning, or whenever this is. Not legal advice. Please like, subscribe, share, comment. Today, I have two topics. One is the result in the case involving Elon Musk's pay package and how the judge got to the result. And I wanted to bring you up to date on the MMTLP side as to the current status of my arbitration. So, before we get started with that, of course, I wanted to address a couple of points that, like I usually do. When a chicken graduates from law school, he becomes a legal tender. I don't know if you guys knew that or not. And when an attorney gets married, instead of the normal vows, they say, "I accept the terms and conditions." While others take a break at lunch, lawyers worked on Cole's lawsuit. And last but not least, these are just kind of thoughts involving lawyers, but lawyers will wish you a happy holiday, but will remind you that they can't guarantee that. Anyway, I wanted to talk a little bit about the Elon Musk Delaware case. So, this was about his 2018 pay package. I've discussed it before, but I wanted to kind of address a couple of really the legal points just to kind of describe how the judge got there, which might help people determine the objectivity of the ruling. So it was a derivative lawsuit filed, class action lawsuit that was filed in Delaware. It was filed by a shareholder, or the lead plaintiff of the case was a shareholder that had 9 shares, who was a former heavy metal drummer, by the way. Now, the benefit of being a named plaintiff in a class action suit is you get a bonus. You'll get a kick, 5,000, 10,000 bucks, something like that. This was a derivative action, which means that the benefits derived from the action will go back to the company as opposed to the individual shareholders. So, um, the shareholder brought an action based upon the pay package, saying it was unfair and it was a breach of fiduciary duty. They tried to get the pay package thrown out. They tried to get it rescinded. They didn't try to get it canceled or voided, which would have made that issue determined. So, in other words, if the relief that was sought was cancellation, it would not only cancel the pay package, but you couldn't replace it with a new uh, pay package. This was rescission, or as we will see, the ruling was rescission, which means you put the parties back in the same position they were. The case occurred in Delaware, and Delaware was a place that often was chosen for entities and corporations to incorporate because it was deemed friendly and private, and lawsuits against corporations were deemed difficult. So when I started first practicing law, everybody incorporated in Delaware, and I think a lot still do, but maybe it's done out of force of habit. But Tesla was obviously referenced there. Um, the decision, so the decision by the court was a 200-page opinion. I've looked through the opinion, and what's interesting is it basically starts off with the question, and the question is, was the richest man in the world overpaid? And I think that question is a problem. So when I get at the end, I'll talk about ways that I think the result may be attacked in the legal sense. But I think that started the statement that focusing on his wealth is not a relevant focus. And again, what the judge did here was to look at the pay package and the fairness of the pay package. And one way the judge looked at that was compare this package with all other packages. That would be fair, but that would have nothing to do with the wealth of the individual. So the fact that the judge started with the wealth of the individual seems to be a factor that the judge should not have considered and would be material and might reflect decisions that were made that were material. So basically, the claim is a breach of fiduciary duty that as a corporate officer and director, you had a fiduciary duty to your shareholders, and that everybody had to get the best job, the best agreement for the person who was in charge of the company. And the best agreement would be at the lowest price. And if you couldn't get at a lower price, that you should actually consider alternative CEOs. I find that silly, but that's kind of what some of the reasoning was. And basically, the pay package was designed from 2018 based upon certain milestones that were met. Those milestones would be either increases in market cap at $50 billion increments. So when they started the agreement, I think the market cap of Tesla was approximately $50 billion. And this milestone agreement would go up to $650 billion. So to get a tranche of options, and I think the total number of options was something a little over 20 million options, and the total shares was something over 300 million shares, potential shares, because they weren't executed. But that was what was at issue, and those options would be divided up into segments based upon when certain milestones were met. So market cap was a milestone, but that was coupled with either certain goals of EBITDA, earnings before interest, taxes, depreciation, or revenue. So one of those had to be met in addition to a market cap. And then if that was met, then he would get one, as it turned out, 1/12 of that total of 20 million or so options. And he would have a waiting period, couldn't exercise it right away, etc. He would pay, I think, 10% of the fair market value or approximately for the shares. And that's how it was set up to go. That was approved by the board, and there was a shareholder vote, and I believe 73% or approximately 73% of shareholders approved that package in 2018. So, how did the judge get to that decision? So, when you're evaluating business decisions of corporation, there's multiple standards. And in Delaware, apparently, there are 3 different standards that are used. So, often the workings of the board will be judged, and most by the business judgment rule, which is basically a very low standard, which means they have to just exercise reasonable judgment in their decisions and they won't be scrutinized. The second level in Delaware, this is talking about Delaware, and I'm not a Delaware attorney, so don't take that as such, is a standard called enhanced scrutiny. So the court would take a closer look at the whatever the issue was, and the strictest standard is called the entire fairness standard, where you look at everything and you're judging the transaction, uh, looking at every little detail. And it's the most scrutiny. So if the judge had used the business judgment rule, there's no way she would have found against Elon. If she would use the enhanced scrutiny rule, less likely, and because there's one additional point, and the entire fairness is a difficult standard. Now, that's a difficult standard because the judge also found that this was a conflicted controller case. In other words, that the person who had the interest involved was conflicted because they would benefit from the grant. In other words, to the extent Elon's involved, he's the beneficiary. So it's a conflicted controller situation. And under that situation, when there's a claim of breach of fiduciary duty, the judge says, and there had been 2 prior cases, I think there was 2 prior cases similar to this where they didn't reach this issue. And there was a Solar City case involving Elon in 2016 where they didn't reach this issue. But the issue became when you have a conflict and there's these grants are at issue, should the burden of proof be switched? So we have the 3 levels standards of judging: business judgment, enhanced scrutiny, and entire fairness. So this case could have been whatever standard the judge chose. The burden of proof could have stayed with the plaintiff. That would be the Torrento. I think Torrento is the name of the plaintiff. And he would have had to prove up the case. But the judge, because found that Elon had control over this specific transaction, controlled the timing, there was no negotiation, controlled the board because they were conflicted, because they had financial interests that were generated and enhanced by Elon, and because the with all that, because the vote of the shareholders was required to ratify it, and since in the proxy materials the proxy statement didn't include that all these directors had these connections and weren't really independent, the court threw out the vote, didn't even consider the vote. So it was a whole series of conclusions where the judge, and she indicates almost with glee in her opinion, that first time and I'm going to go for it and here it goes. So she selected the most vigorous standard of proof and flipped the burden. So it put quite a heavy burden on the defendant Musk in this case, and that's why the result was reached. It was that procedural twist where she used the most aggressive evidentiary standard and then imposed that on Elon. That made the burden on the defendant really difficult. And it made it kind of generally contrary to American law. In American law, on most occasions, the plaintiff bears the burden of proof. And here we had a different situation. On top of that, she focused on his ownership, 21.9% ownership, that was sufficient. And she compared the plans to other plans and said it was substantially greater than any other plan that existed. But again, in reality, it's that burden shift that forced the defendant to try to carry the day on with a very heavy standard of proof. And since that issue has not been adjudicated before, and since the judge seemed to focus on his wealth, which is an irrelevant factor, I think if he appeals, those will be interesting. And on appeal, and again, what Elon's team decides are appropriate appellate issues. But I think the burden of proof shifting will certainly be an issue. I think the standard of proof, the choice of the standard of proof, will be an issue. I think the fact that the remedy of rescission was chosen, so rescission was the remedy that the court imposed. It ordered the parties to get together and figure out the language. In effect, it puts the parties back in the same position as they were in 2018. That's the idea. However, there's much activity that occurred after 2018 in reliance upon this future pay package. Elon bought Twitter, for example. Probably would not have done that without the pay package. So how you put people back in the same position where there's tons of people that were not parties to this particular lawsuit that were impacted, I think that's the wrong remedy. I think some kind of damage remedy would probably be the only remedy that would probably withstand scrutiny, where only the parties that were subject to the judgment were before the court. So in effect, I think the court is influencing and impacting parties that were not before the court and that didn't have a chance to participate. So the rescission is the court is waiting for the parties to get together to work out the language. If they can't, the judge will do it. And then on top of that, there'll be an attorney's fee motion. The prevailing party, the winning party in this case, would be the plaintiff, and the attorneys will get a fee award. What that is, we don't know. Is it an hourly fee? Is it a percentage of the total package of option package is $55.9 billion, I think, as of today, but it's not exercised. So it's not worth that. And I think the present value of that package, because there had to be an accounting of this, was approximately $2.5 billion. And one of the problems about that designation was, I think they referenced the milestones, those movements in market cap could be easily achieved, and they were factored into the calculation. of what the value was of the unexercised option, and that's $2.5 billion. So, typically in a class action, the lawyers on the prevailing side will get a percentage up to maximum 30, but I think it's 25. It could be 30, it could be higher, but I think that's pushing it, of the award. But what's the award here? Is the award here the $55.9 billion? Is it $2.5 billion? Is it some other factor? So they will get a percentage of that. And I don't know what it will be, but that's what's generating and moving the case, nothing else, because it's the lawyer's fee, which will be substantial, which is moving the case. The fact that the judge focused, and I read you the statement about the richest man, I think that's an improper analysis. And the fact that it's the very beginning of the 200-page opinion, I think that she had a prejudice against Musk, and this is just my opinion, based upon the fact that he was the richest man in the world. Why put it in otherwise? Again, his wealth is irrelevant. It's the pay package. So I think that's a problem, and I think that will come up in the appeal. The lack of sufficient evidence from shareholders regarding the benefit, whether they were confused and whether they would adhere to the benefit, I didn't see it referenced in the opinion. And I think since the issue is damage to shareholders, and since the only shareholder, the plaintiff, was a 9-share shareholder, there probably should have been surveys or general surveys of the shareholders with regard to notice, with regard to their interest, etc. So those are just some of the ways I think they will appeal. I'm sure they will have a multitude of other ways, and even though in general the likelihood of prevailing in an appeal is less likely than not, I think they have a good chance here. Again, it's a case of first impression, so it was the first decision of this in Delaware. So this judge is basically making, and I don't mean this in a pejorative way, but since it's a case of first impression, this judge is just declaring the standards. I don't think some of the standards are well supported. She also has prior history with Elon. So I think it would be an interesting appeal, and I think there's a decent chance of success, again, based upon the evidentiary change, the burden shift, and the harsh evidentiary standard. So we'll see what the final judgment is. We'll see what the language is, and then we will see what happens. I'm not sure of anything, but I would guess there would be an appeal. And I think there also will be a new plan. That's what I discussed. And they certainly can create a new plan that addresses the 2018 period forward and appeal at the same time. And they could put language in the new plan that deals with the possibility, if they prevail on the appeal, what happens to that plan period relating to that 2018 period. I think all that can be dealt with. And obviously, I think, and we discussed it, they can incorporate in other states, and I think they will, and I think they're going to incorporate in Texas. I think the pay package, or whatever pay package they come out with, probably would be prepared after they move, and that's it. So that's kind of the update in terms of the Delaware opinion. I just wanted to focus again on the legal stuff, where the judge, I think, kind of shaped her ability to make the ruling, and I think it's ripe for appeal. And again, it's a case of first impression. Last but not least, and I will quickly do this, I'm bringing people up to speed on my arbitration regarding MMTLP. So up to date, June trial date, I filed 2 motions. So separate and apart from whatever I've said in the past, filed a motion to compel production of documents. They have not produced the documents they were supposed to after a protective order was done. Within 2 hours of me filing that motion to compel, they sent me discovery. That's yesterday or the day before. And yesterday I filed a second motion to compel discovery. So 2 motions to compel discovery are outstanding. We're still exchanging documents theoretically. I'm awaiting additional discovery from them. And that's the right up-to-date matter. Obviously not a big fan of the arbitration or the arbiters. I haven't mentioned their names. I've elected not to at this point, but I'm not a big fan. And I'm not a big fan of the process, but I've tried to discuss it so people would be aware of the process and it wouldn't be hidden. But to this point in time, on any issue where there was a dispute as to any process of the arbitration, the arbiters have refused to hold any hearings and have refused to provide any reasoning for their decisions. So, silly me, I think that's inappropriate, and I'm going to keep on pushing. So, we'll keep you apprised as we go on. Again, that's the MMTLP arbitration against Fidelity. Obviously, a lot of news today about it, but that's it. And last but not least, as we leave, why are lawyers uniquely charming? Of course, because they have their own appeal, perfectly relevant to this case. So, everybody out there, be well. Thanks for hanging in. You have questions, comments, please post them. I will, if I can add anything of a cogent nature or semi-cogent nature in response, I will, but I will certainly look at all the comments. Everybody be well. Have a great weekend and take care. And this is the end of the